Hey guys, it's Kathy. I hope you're doing well. So we made it. We made it to another day. It feels like we just stopped the last stream and we're starting a stream again. It's probably because the last stream was a little long. This stream is the opposite of that. This stream is going to be a little short compared to my other streams. I don't mean an hour. It's not really short. An hour long stream. That's what we get today. We get an hour. So the one I want to start with, okay, we get Judge Fleischer every day, not today, every day from Harris County. But there's other judges there, and we don't see them as much because, they're different. They're not Judge Fleischer. They're judges, they're Juanita's great, so I have a little bit of Juanita today. But the reason why I wanted to show you Juanita, not because it's pretty cool what she did here, but it looks like she got a whole new camera system. You'll see what I mean. The camera shots in Juanita's courtroom, which is like right beside Judge Fleischer's courtroom, are way different. The cameras are way different, and it wasn't like that before. So I'm not saying Judge Fleischer's going to get new cameras soon. I know a lot, that Judge Fleischer's camera for on him isn't working correctly. Guys, he'll fix it. Just he'll fix it. I think someone posted a comment in my comments telling Colin to fix it. Guys, I got news for you. Colin does not read my comments. I also got another comment that I deleted. Let me tell you, it started off saying how I was biased against men. Maybe, maybe not. That's not why I deleted the comment. But then the commenter went on to say Judge Frost is only a magistrate. And that ticked me right off. I didn't want to delete the comment. I wanted to post it somewhere, but then I thought, no, but I'm not going to leave that there because we're not going to disrespect Judge Frost. No, we're not. Okay, I saw that. Is anybody else having issues hearing me? Because that would be a blessing, not a curse, child. Yes, my kids. My kids would love it if they could only hear every other word from me. They hear words I don't even say sometimes. My son got into a whole fight with me a couple days ago because he thought that maybe I was going to say something. Oh, yeah. It was funny. I'm going to do it again today for something different. Okay. We got a new judge from Wisconsin today, and he's annoyed with everybody. It's not crazy, but it was so hard to get this judge. I worked for this little clip. It's not the greatest clip in the world, but since I worked so hard to get this clip, we're playing it. He's annoyed at everybody at first, and then a whole bunch of lawyer stuff. I do say words that I'm sure I say. I'm sure I said it, Darkest. I am sure I said it. Okay. Happy Father's Day. Happy Father's Day to all you dads. I hope you guys have a good day. I hope you don't get socks. I hope you don't get a tie. Do they even give ties to dads anywhere for Father's Day? But no, I hope you get a chance to relax. And I mean, this is a little shameless of me, but go to a local brewery. You'll have fun. That's your home. Go buy an $8 beer from a local brewery. Yep. They have sports on TV. I mean, okay, you can take everybody with you if you want. Or if that's just it. On Father's Day, do you ever notice this, guys? So on Father's Day, fathers want to go out and do stuff with the family, like the whole family go out to dinner or whatever. On Mother's Day, it's like, I want everybody to leave me alone. Give me a massage somewhere else or whatever. But that's what I want for Mother's Day. I don't want anybody to talk to me. Leave me alone. But then someday they move out, and then you're like, oh, I wish they would all bother me again. Then they move back in, and you're like, damn it, I shouldn't ask for that. Yep, see? Fuzzy's doing for Father's Day. He's got a TV, a ping pong table, a pool table, a beer fridge. He ain't going nowhere. People come to him. I'll be over. That is true. Darkest Night. I can't actually put your comment up on my stream or even say what it is because people say I'm biased against men. All right, I'm going to. I don't care. Come at me, comments. Come at me. It's true. Okay, let's go to Juanita, guys. Let's go to Juanita. It's just a real short clip. And check out her cameras. I'm just saying. Maybe Judge Fleischer will get these cameras soon.
Yes, Your Honor, on June 6, 2024, also was dispatched with a call for disturbance located at 310 West Alabama Street in Harris County, Texas. Officer arrived on the scene and made contact with CW. CW is an employee of the convenience store Tiger Mart. CW asked the defendant was in front of the convenience store harassing customers, so CW went outside to tell the defendant to leave the property, but the defendant refused. Defendant then came up to CW's face and stated, "Get back inside before I hit you and put you down." CW stated that he felt in fear for his life and safety and did not wish to fight defendant, so he started backing into the store. While CW was backing into the store, defendant threw a plastic bottle at him and other trash. CW was able to identify defendant after officers detained defendant. While in the patrol vehicle, defendant made 2 res geste statements saying, "Yeah, I threatened him," and "Yeah, I was over there asking people for food."
And his charge is
terroristic threat.
And he
said, "Get back inside before I hit you and put you down."
He said, "Come at me."
That is not serious bodily injury or death. So therefore, there's no probable cause. Mr. Bowden, stay away from the Tiger Mart. You understand that? Do not go back over there. Do not step foot in that parking lot. Do not harass that man. Okay? You hearing it from me?
Yes, ma'am.
Okay. Now look. The trespass one, every time you come over there, you're gonna get arrested. You get working.
No, ma'am.
Okay? And I get and I understand that you're probably unhoused right now and you're making some options to live on the streets, but you gotta stay away from places where people don't want you. Okay?
Yes, ma'am.
Because all it's gonna do is get you back again. That's not your goal, is it?
No, ma'am.
Okay. And I wish you the best, but this is not. We don't need to be using county money for this and our time for this. Just stay away. When somebody says they're not interested and they're not gonna help or go away, they're trying to handle their business. Okay?
Yes, ma'am.
So don't go back over there. You understand that?
Yes, ma'am.
So just have a seat.
Stink Eye, that comment is for you. You can't fix them. If they say they're not interested, move on. All right. Now we're going to go to somewhere else. It's not Harris County, Texas. Okay. Maybe I'm wrong. Actually, Carolyn might be the one to tell me right away if I'm wrong. But I think we're going to the orange shoe lawyer. But she doesn't have orange shoes on today, but her shoes, never mind. I'm not going to give my opinion. Anyway, I really hope that Judge Fleischer sort of doesn't get these cameras, and I really hope that he does, because they move around too damn much. They move around as soon as someone talks, they all go shh, shh, shh. And the one at the top here, I think you can see my mouse. Like that is, it's a panoramic. So this is the whole thing in one, which is, I don't know. Yeah, yes, it'll be a bit too much motion going on. And I don't know, what if it doesn't catch him going the whole way forward in his chair? What if it's not fast enough? We need like more cameras on there, 360. But we'll see. Yeah, it does it. It actually makes me feel like I'm watching Creepshow. Hi, Shauna, do you remember Creepshow, guys? All right, I'm going to the orange shoe lawyer. I think it's a different judge. It's down in Georgia. It might be a different lawyer. I might be wrong, but she's just angry. She's just angry.
All right, so what happened just now, just the update, the clerk is Mr. Faircloth's had an opportunity to speak to probation and to the officers who are here this morning. He's asking for a continuance based on the fact that he'll need to subpoena the witness to have them here. Is that correct, Mr. Faircloth?
That's correct.
And of course, the defense is objecting to that. And I'm just asking this in hopes that it could be resolved today, but even under a preponderance standard, Mr. Faircloth, you feel that that's necessary for the state to make its case. Is that correct?
That's correct, Judge. Basically, what we're doing here is my understanding is a forgery charge, which, regardless of which standard is applied, we get a reasonable doubt or preponderance. One of the necessary elements has to be proven is parental knowledge of the lack of authority to have or tender the document that is not authorized by the victim. As the victim is not here, we would not be able to prove that element.
Nobody else can testify as to that. All right. Over the objection, I'll continue.
Right there. That's it. That's what did it. She is annoyed now. Over the objection, I'll continue. But he has to continue this because the victim's not present. And yeah, the victim should be present, blah, 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 but it doesn't matter. The victim's not present. So now she's annoyed, and we're going to get to see her shoes in a second.
Try to bifurcate the hearing. I don't know. You want to try to do that? Yeah, then that's fine. Don't do that.
That guy talking to the prosecutor is the sheriff.
We could bifurcate this hearing and go ahead and get testimony from 2 officers so they don't have to come back. I'm fine with doing that if the court and defense is all right with doing that. If they're going to be required to come back and doing that, but if we can go ahead and get their testimony done and release them, then I'm fine with that.
I object to a bifurcated hearing, Your Honor. There are situations where we might need to bring all the officers based upon what this alleged victim is going to testify. And I think that would just cause more confusion in the long run. And we still do object to the continuance straight up.
Judge, she's only going to bifurcate after a little bit of wine.
Okay, well, I understand. Let's just continue it. Let's continue. You don't want to do it on the 25th?
We'll have to postpone it till I have an officer that has made medical procedures that needs to go, an appointment that he needs to go, so it's going to have to be pushed to the 15th.
Okay.
July 15th or June?
July
15th.
All right.
Yeah.
Let's continue.
Yeah.
On Mr. Carter's matters,
I got to talk to Carter and Isaac. I thought we were doing this one first, and I was.
you were coming in hot. I get it. All right.
I shall.
And my understanding, there is a fellow back there that might be on here and all. I don't have any warrants yet, but it's not. I'm going to send traffic.
Yeah, that's now.
She was back there for a while
Mr.
talking
Carter.
to him or bifurcating. I don't know.
And we would invoke the rule because we've been on witness on this case.
All right, setting it up. We're here on position 1. It's 2010 CR 0020, State of Georgia versus Tyrone Carter. And position 2, 17 CR 0025, State of Georgia versus Tyrone Carter, TYRON. We're here for probation revocation matters. Mr. Carter has requested a full hearing, and the state has multiple witnesses. Is that correct, Mr. Fairclough?
Judge, my understanding is that Mr. Carter, he's got a couple of different technical violations as well as a new charge for, I think, it's damage to property. And based off of speaking with Officer Giles, we're going to be proceeding on technical violations. And the same situation as on the last case. We don't have a victim for the property count, but he's only got a little over 2 years left anyway. So we're going to proceed with Officer Giles as far as the technical violation.
All right.
Well, can we renegotiate if all he has is net violations?
I mean, he wants to get 2 years revoked and terminate that. That's something to ask for.
So the fact that we don't have new charges now, he can't have like PC time or anything?
I mean, we can do that here real quick. I mean, if he's here, that's fine.
What do you want? I'm saying we're revoking for 2 years on technical violations. For the technical violations.
I only got a technical violation for not being seen for 1 month, and I got a technical violation by my affidavit saying that I was not doing that and not paying the fine. I don't see why I should vote in the period.
Your Honor, let's do an admission with argument. We don't need to have a full hearing for that, but I will need more time to speak to him.
You need additional time to speak with him.
To do an admission with argument, Your Honor, because I've been led to believe we're having a hearing. And I went back there and talked to him for however long, and then we get everything switched around.
You want to go?
All right. If you need additional time to talk with him, then take it, please.
All right, let's. For our admission with argument. We'll just give a profit, Your Honor. Argument.
All right. Again, we're here on the cases involving Mr. Tyrone Carter. Mr. Carter, will you raise your right hand?
All right, here's what's going on because a couple people don't know what's going on. She came into court today to have a hearing with that other guy. They were supposed to have a hearing with that other guy, and they didn't because the witness wasn't called. That's the prosecutor's bad. Let me tell you, that was their bad. Anyway, victim wasn't called. Victim isn't here. No hearing. It was continued. She's mad. So the judge is like, okay, let's go on to the next matter, have a hearing with them. Well, she wasn't ready for that. That's not what she had planned for today. So they want to do a plea. All right, this guy violated his probation. He's been on probation for years, and now he violated it. I think he was supposed to be on probation for 7 years. He has 2 years to go, and now he violates his probation a couple times. So she wants to go ahead and do an admission with argument. So she's going to admit that he violated his probation, but she has some argument to go with it. Well, that's not going to work out exactly how she wants it. So that's where we're at right now. She's about to try to do an admission with argument with the judge right now.
Do you swear the testimony you'll give to the court this morning will be the whole truth and nothing but the truth?
Yes, sir.
Did you receive a copy of your petitions in each one of these cases? You can put your hand down.
Yes, sir.
Is this your signature on the back of these petitions?
Yes, sir.
All right.
And I just want to make sure.
Yeah, Your Honor, we do not stipulate that he moved. If Your Honor needs to have a hearing about that, that's fine. We do stipulate that he did not pay that money. We can give an explanation during the proffer, or you might want to hear witnesses for that particular count. But we are, and obviously Your Honor can revoke whatever you want for him not paying. That's the part we stipulate too.
So where are you not?
We're not admitting that he moved because he did not actually move.
Okay, well, we'll just have a hearing. I mean, it's something
Yeah, I-
to deal with that, try to piecemeal it out.
We're
It's
in
like,
court, Fozzie.
Then what the
There
heck
you
are
go.
we admitting here? Are we having an admission with argument, or we need to have a full hearing? Because I'm confused now.
I mean, I've been confused for a long time because I go back and prepare for something certain and then something changes. So
Judge, given the fact it's going to be a one witness hearing, I would just go ahead and have the hearing. It would be done.
All right, let's hear it.
Oh,
She was back there for a long time.
swear testimony
Again.
about giving the court the truth, hopefully nothing that be done.
I do.
Will you please state your name,
Sheila Giles,
where do you work,
Department of
okay, how long you worked there?
10 years this past November.
Okay, and what are your duties there? Do they include supervising probationers? Okay.
She's a
And
probation
does that include
officer.
Tyrone Carter.
It-
And you see the person that you know as Tyrone Carter here in the courtroom.
I do.
Could you point him out for us? Okay. And the record reflect that you identify the defendant.
It'll reflect.
Thank you. Now, has Mr. Carter been under your supervision as a probation?
He has.
Okay. And has that been for a significant period of time, for a short period of time? Roughly how long are we talking about?
On and off, I believe me and Tyrone have been since I took the Trutland County caseload. So probably 8 years at least.
Okay, because this stems from violations back in 2010, it sounds like. So he's been on the charges, I guess, the entire time he's been a probation officer.
Yes.
Okay. And so as far as current violations, what specifically are you aware of?
When it comes to not paying, he has not made a payment. And when it comes to moving, I was unable to see him in the months of March and April of this year.
Okay. So we'll start with paying. What is he supposed to be paying roughly, and how long is he paying that for? How long since he's paid last?
I can't remember exactly when the last time he paid, maybe 2022. But he knows he's supposed to make monthly payments. We talk about it.
Is probation fine or restitution or
Court fines and fees.
court fines?
There's no restitution.
I got you. And so he's supposed to be paying court fines and fees every month.
He is
And to your recollection, he has not done so in approximately 2 years.
at least that long.
And you attempted to make him aware of his legalcy in that.
Yes, we talk about it monthly. He knows, and he knows how to pay, and he knows how to reach me if he loses something, forgets, whatever.
Because he's been on probation for this for years, so these same conditions have applied during this whole period of time, correct?
That's correct.
So these are not new things he's having to learn to do.
No.
Okay. What, if any, explanation is he given as far as why he stopped paying a week ago?
He doesn't really give an explanation. I know that he helps his grandma a lot. And so I would think that the majority of what he does make goes to help his grandma's household.
Is that something that's been a new thing that's developed in the last couple of years?
No.
No.
That's
It's been a consistent thing the whole time too.
It has.
So are you aware of anything that has changed in his life through his own missionary or other independent knowledge that would cause him to suddenly go from 10 years ago to just not?
No.
Okay. He's offered no justification for that.
No, he pays sporadically when he gets a job, but it's not on a consistent basis.
I got you. Now, in regards to him moving, you said that in March, April, you had tried to locate him.
I did.
Now, prior to March,
Come
April,
at
you been
me.
able to locate him.
Yes.
And he'd been living in the same place for a long time.
Yes.
What place was that? Was that his own house or somebody else's house?
No, he lives with his grandma.
Okay, so he'd been living with his grandmother up until a couple months ago, or like 4 months ago.
Yes.
Okay, so when you visit with him, do you go by every month, or is he coming in most of the time and you're going by periodically? How does that?
No, I go by his house. He's on the caseload where I have to keep him at home. And for the most part, throughout the years, he's compliant as far as that goes. It was just the past that March and April, I couldn't find him.
Okay, so you were able to find him at the grandmother's house in February, but both
I
in
would-
March and April did not.
I could not.
Did you get any indication as far as were you just missing him or that he moved or what's your understanding?
If I miss him, I can usually call Tyrone and he'll say, I'm going to be home this week, or but I was unable to reach him in any capacity those 2 months.
Did you leave him any type of notice that you could go by to see him either physically or digitally or otherwise? Like, are you
I usually leave a sticker on the door, or I communicate with his grandma.
okay? And to your recollection, did you attempt to give him notice that you had been by and could not reach him?
Just on the door, because I was unable to reach the grandma those months
Okay.
either.
Did you see any sign of anybody living there during the last 2 months?
Grandma lives there, but she just never came to the door, or she wasn't there when I was there, but I did leave a Post-it note on his door.
I got you. And from the time that you go out in March and
You
first
can
get
if you have
fined
tacos.
through April, you still can't find him.
Hi,
At
Chrissy.
any point during that period of time, did he ever contact you back?
No.
Okay. Since that time, did he ever contact you back before he got apprehended?
No.
Okay. When was he arrested? Roughly.
Sometime in May, but I don't remember exactly.
Okay. So we're talking about a gap of at least a couple of months when you first started letting him know, yeah, I've come by as I do every month. I cannot reach you. So sometime in May where he's not responding and you don't see him until he's arrested.
That's correct.
Okay. When he was arrested, did you ever go and talk to him?
I did.
Did he have an explanation as to why he had not been around or moved, whatever he did for the last couple of months?
He didn't say.
Okay. I don't have any further questions.
Thank you. So you have supervised him for at least 8 years, off the top, correct?
Yeah, it's been since I took the Truth County caseload, I've had Tyrone.
And generally, he's been communicative.
He is,
And generally, he's made payments when he can.
when he can.
And you are aware that he does have family obligations. He supports his grandmother and other people in his family.
I am.
And you're just saying that he hasn't made a payment since.
So that's the part that gets me. So he has money because he has to support this whole family. So obviously he has money because he's the one supporting him, but he can't put $5 down because he doesn't have any money.
2022.
That's correct.
And could it be possible that he just doesn't have any
Gutsy.
money?
Objection,
Gutsy,
calls for
Laura.
speculation.
Your Honor, she took out warrants based on results of that speculation. So I would say that that is relevant to the ultimate issue.
She took out warrants based upon his failure to abide by the conditions of probation, which required no speculation because the objection did not.
All right, this is saying that don't speculate, just tell me what you know.
Thank you.
Did you try to research how much money he was making or anything versus, how much he could have paid you versus the light bill and all that?
We've had conversation about, I don't care if you only pay $5 to make a payment.
Okay.
And he's aware of that.
But you don't know how much he makes total or what it's billed equal.
No, because sometimes he works and sometimes he does not.
But he is the primary caregiver for his grandmother.
I know he helps his grandma a lot, yes.
And you were saying that you stopped by his house in March and April and he wasn't there.
That's correct.
How many times you stopped by his house?
2 to 3 times probably both months.
Okay. So
Me too.
on, say, a total of 6 occasions he wasn't at his house?
That's correct.
Okay. And what times of the day is this?
Just throughout the day. I mean, I don't remember specifically, but like I said previously, usually when it comes to Tyrone, if I can't find him at home before the month runs out, because he knows he has to be seen monthly, I can pick up the phone and say, what days, where are you? But there was no communication on those months either.
But as far as verifying if he lived there, you stopped by 6 times in at random times.
Correct.
And you have no information that he's living in.
No, I just can't find him.
Okay.
Darkest is 80.
And you were saying he was arrested in May, but you took out that warrant on April 24th, correct?
Correct.
No further questions.
You were correct.
Yes.
Someone please explain to me what the heck she just did there. Like, did she do anything at all to help anything? I'm trying to figure out. I heard her talking about Tyrone the whole time, but she didn't say anything like at all. Okay, whatever. Just keep going.
Nothing further from the state.
Sorry.
I'll wait, Mo.
Thank you, Your Honor. This is a situation where, and like I said, he hasn't paid. You know, we would argue he doesn't have enough money. You know, she said he could make $5, but we're all aware that there are times in society where people, you know, if all they have left is $5, they go to buy some ramen. You know, but he did not pay. And if Your Honor wants to revoke him for not paying for a reasonable amount of time, that's fine. You know, maybe 6 months PDC, something of that, because indeed he didn't pay. Now, as far as the moving without permission, there is literally zero evidence for that. Now, if they want to charge him with not reporting or not communicating, that would be one thing. He's charged with moving without permission. And Officer Giles admitted on the stand that she had literally no evidence to demonstrate that he moved. She didn't have a lease with his name on it at some different apartment. She doesn't have closing documents where he bought a house. There's no mail of his going to some other location. There's literally no evidence he moved. She stopped by his house, and I get that that's their procedure. She stopped by his house approximately 6 times in 2 months at various times, and he wasn't there. Your Honor, not even by preponderance of the evidence does that equal that he moved. And yes, should he have been in communication? Of course. You know, if he wasn't in communication, he's been in communication for all these 8 years. And for some reason, maybe he wasn't. But
I can't listen to her, guys. I'm trying, but this little weight, that little weight top of her show is very, very, very distracting me. I just can't help it.
that's not what he's being charged with in the petition. He's being charged with moving. And there is literally zero evidence that he moved. Not by beyond a reasonable doubt standard, but not even by preponderance of the evidence. There's nothing to demonstrate he moved. Like I said, Your Honor, we concede that he did not pay since February 2022. And granted, we can argue all day that, you know, he's poor, he's unfortunate, whatever. Officer Giles is right. He should have probably paid something. And we believe that maybe 6 months PPC time would be a fair disposition under these circumstances for the failure to pay.
Thank you. As far as the payment, the problem is not the money. Like Officer Giles said, he would have paid $5. That would be plenty. The problem is just not doing what he's required to do for probation and not failing to comply for a few weeks or even a couple of months, but for years. Probation is already a privilege and something that is used to give people the chance to pay their debt to society, not have further problems, not have any type of incarceration time, or at least less incarceration time. And sure, it's a great thing, but it is not. And it's a duty and responsibility of the person who's on probation. And it's not a duty and responsibility of probation, of the court. Julie Giles is not his mother to go and find out what he's doing and where he's going and all of that. He bears all of that burden. He bears all of that responsibility to make payments. If he can't make payments, to give some reasonable explanation as to why he can't make payments. This idea of, well, bless his heart, trying to help his grandmother, he may very well be. I hope he is. That's great if he is. He's also living at her house rent free while he has swaths of time where he's not even working. But that is what it is. He's not coming to her when she's visiting or when he's going in to see her and saying, hey, things are really tight right now at home. Can I get a break? Can I do some community service on my fines instead? Can I just give you $5 for a few months until I get things straight? I think we all know that she would have worked with him. She's testified that she would have worked with him. Instead, he has no explanation. And this is not something that's a bad patch for a week or a month or 6 months. It's over 2 years. Then, saying that he's going to have no real consequence of bad things, well, now I'm just going to not be where I'm supposed to be. Because, again, let's be clear, It's not about him having a lease in an apartment somewhere else or him owning a house somewhere else. He can buy a house in every state, the entire United States. Be the main person on the deed for all of them. Not a violation of probation. What is a violation of probation is him not residing where he said he's going to reside without notifying him that he's going somewhere else. And after checking multiple times, not once, not twice, but 6 times over the span of 2 months, he's just not there anymore. And again, it's not her responsibility to stake out his house and see if he ever stops by to visit his grandmother from wherever he's staying now, or to track down where he's living now. It's his responsibility to be there. He's the only one with a responsibility. The only responsibility she has is she can bring a violation, have proof. And the proof is he is not where he's supposed to be. He is not residing where he's supposed to be residing. And he has failed to give notice of change of residence, regardless of where he's staying, whether he's on the lease somewhere else or he's sleeping on somebody's couch. Bear in mind, too, this went on for months. And then after the warrants were taken, they still couldn't find him. For I guess at least weeks, because he didn't get arrested sometime in May. So even with warrants out, he was not easily located. Asking for 2 years for technical violations is not something that we do frequently or we do lightly. But where you've got people who are just not abiding by conditions for years, and it's not something where there's some reason they can't do it. They're just choosing not to do it. Thumb their nose at the conditions they have. It's not fair to every probationer, the vast majority, that does do what they're supposed to do, that do pay their fines, that do stay where they're supposed to be staying, that understand this is an opportunity and a privilege rather than something to be thrown away when they're tired of.
Honestly, we do not hear the prosecutors say this enough. Probation is supposed to be an alternative to jail. And if he was in jail, he would be where they want him to be. He's on probation. He should be doubly sure they know where he is, because it's real easy for them to find him if he's in jail. And, lots of people on probation do work and we don't get to see them, but we see people like this. No judge that I've seen yet is going to put someone back in jail because they didn't pay. They're not going to take someone off probation because they didn't pay, unless it becomes contemptuous. But him just going away for 2 months, if he's in jail, they don't have to worry about that.
Doing it. So I say all that to say, this is a serious matter. This is something that shows not a lapse, but a long-term abandonment of the responsibility.
Oh boy, do I got a video for you today that dads are going to like. I got a nice Father's Day video coming out later, but it is 2 hours long. But it's all about car parts and restoring old something or another. And breaking contracts. Let's put that in there.
That is part of being on probation. And so he doesn't need to be on probation anymore. I asked that you revoke 2 years, terminate the balance. I think he's got until 2027 on this, one of the cases. And so just terminate the balance, revoke 2 years, and he's no longer a candidate for probation, obviously. So that's what we'd ask for the resolution sentence to do.
All right, find by preponderance of the evidence that Tyrone Carter, you violated terms of your probation. After hearing evidence and testimony and considering the facts of the case, I'm going to revoke you. $2 years, terminate balance, $0 bond on release.
Thank you, Judge.
Ooh-wee. If that lawyer was angry before, she is really doubly angry now because Tyrone just went to jail. The favorite part of that accent, I don't know why, is no. Like all they have to do is say no, and they're from the South. And it's like this real long word. It's 2 letters, and it's this real long word. I feel like playing that again just so I can hear all of that accent all over again. Yep. She's going to have to doubly bifurcate because of this one. Yep. She objected to the bifurcation, Carolyn. She objected. She was very, very mad. Okay. Next up in our lineup tonight is a new judge. He's a new judge from Wisconsin. Do not get excited. The Wisconsin accent is a little bit there, maybe. In the pauses. So he has some issues with the gallery. And you're going to hear his issues within the first few seconds of the clip. He gets the lawyers, he gets the gallery, he gets one more person. Oh, the interpreter. Everybody's annoying him. But when there's pauses, when there's breaks, you can hear why he's upset with the gallery. So to listen for it. Yeah.
Were sight and sound sufficient? 23 CF 117, Mr. Schmidt, does the defendant have a copy of the criminal complaint?
We do not have a copy of the criminal complaint.
Why didn't you tell me this before court?
Well, we've been doing many things and we didn't realize that there was no complaint or that it was sent out for initial. That information should be sent to us prior to the hearings.
Okay. We have several things here that are going to make not a very good record. We have folks not allowing time between interpretation and English. We have the interpreter providing the interpretation at same volume or a louder volume than I'm hearing other people. Yeah. A little person in the courtroom that's at times not comfortable telling us to leave, but it's not making for a good record. So how about this? How about we just talk about bond? Can we just do bond, attorney form?
That's fine, Your Honor. Would you like me to?
Yeah, what's your request, please?
The state is requesting $500 cash in each case. The defendant has been in bench warrant status for 1.5 years in 22 CT 451. He failed to appear at a plea and sentencing on January 20th of 2023. Given the length of time in bench warrant status, the state does believe cash bond is appropriate. We are asking for $500 in each case. As to 23 CF 117, the state is requesting the non-monetary conditions that the defendant not possess or consume alcohol, that he have no presence in bars, taverns, or liquor stores, that he not drive without a valid driver's license, and that he be placed on scram electronic monitoring. Your Honor, This 23 CF 117 will be the defendant's second OWI, second case.
Va a ser el segundo caso de manejar borracho para este acusado.
Which is why we believe the screening condition is necessary.
Por eso creemos que como condición el alcoholímetro es necesario.
Thank you.
Gracias.
Mr. Schmidt or Attorney Bartek?
Very well, Madam Bartek.
Thank you, Your Honor.
Gracias, Susana.
We're asking for the court to impose not more than 500 across both files.
No pida más de $500 en efectivo para los dos casos juntos.
As to 23 CF 117, the missed court appearance was due to Mr. Alcio Rayo being possibly hospitalized at this point after an incident, and that was his reason for not appearing. Additionally, he is eligible for public defender representation, and we do need to update the address, as that also had changed around the time of the summons being sent out in the CF case.
The good part is over. You can see the toddler in the courtroom right there. And, you know, it's a baby. They make noise. They make a lot of noise and a lot of mess and a lot of smell. But the baby's making noise. So that's the one person that he was complaining about. The interpreter is too loud because the microphone was right at her. That's the second person. And the attorneys didn't have the complaint given to the defendant. So the best part of this case is over. But this court was so hard to get that we're all watching it. No, we don't have to. Well, we'll watch a little bit more. Yep. The toddler was making noise, let me tell you.
Mr. Palacio Rayo, he has lived in the area for many years. He does have family in the area, so he does have significant ties to the area, and he would be represented by our office after today.
Well, let's get that address, please, Attorney Bartek. That's awfully important.
Oh, yeah, I wasn't unmuted. It takes a second to get the address, guys. And you can't hear the toddler right now, even though the toddler's making noise because I had it muted. Hi, Lisi. You're fine. It just takes a while. It's okay.
It doesn't come up. I hear Attorney Bartek. Did I hear the address?
Were you able to confirm that? Yeah, is that consistent with you?
Es consistente.
Just doing a visual search, that does not come up as a Port Atkinson address, but I've noted the address as given by the defense.
Yeah.
New Jersey would never, ever let them out. They checked that address right there in court, and if it's not a good address, nope, You're not going nowhere.
You're going to want to make sure that we have a good address. The courts, they often communicate with the address that you report. It doesn't seem to be coming up, at least via Google.
Parece en Google.
But that's what we'll have down.
Eso es lo que vamos a juntar.
In 22 CT 451, well, in both cases, the court does believe that cash is necessary. Certainly, if the hospitalization is the reason for a non-appearance, courts would certainly like to learn more about that. And but here and now, we have to make sure this defendant is accessible to the court, and based upon what I have, I'm concerned that if there isn't a considerable amount of cash, especially in 23 CF 117, it's going to be troublesome to ensure future appearances without that amount of cash that the state's requesting. So in 23 CF 117, the court is requiring $500 cash. $200 cash in 22 CT 451. Special conditions requested by the state appropriate.
Also acepté las condiciones que el Estado.
Yeah, I heard the record possible hospitalization, and it's just
posiblemente en el hospital.
It's not helping to allay the court's concerns here about appearance. So, we know these things can be reconsidered and talked about later, and things can be.
Okay, Judge, that's enough. We heard it. His bond is a couple $100. 16 days, 22 hours, 37 minutes, 28 seconds. Woo-hoo. Okay, that's a Wisconsin judge. I like him. I don't like the audio in that courtroom. And he is just damn hard to get. It is just so hard to get. I don't know if I'm going to be able to get him again, which is probably good because the audio is just terrible. All right. Last clip, guys. Last clip. We're going back to Jersey to that judge again. And it's the same attorney with the hair, the thing on her head. Hi, Grammy. So we're going back there for another one. Yep, Joycey. Going to Joycey. As soon as I click at this button that I can't seem to find right now. There we go.
Okay. State.
Your Honor, as for the challenge to probable cause with intent to distribute, we'd like to refer you to the portion of the affidavit of probable cause, which mentioned the center console containing a small digital scale, which is and oftentimes an indication of someone who is engaged in an operation where they would be selling narcotics. And we feel that would be sufficient to demonstrate probable cause with intent to distribute.
Very well.
Powerful argument.
Ms. Cox.
Judge, the vehicle in question does not belong to Mr. Green. The other items, and probably most importantly, the firearm was found in a fanny pack behind the center console, which the officers claim also contained a wallet belonging to Mr. Green. Obviously, we're not challenging that, but I think that probable cause really can't. I know it's a very low standard, but simply having a digital scale with one vial full of heroin, unused heroin, and then a very small amount of other drugs with no packaging materials, there's no other indication whatsoever. Simply having one scale, we don't believe meets even the very low threshold to establish probable cause for the intent to distribute those drugs.
Sure. So the court has reviewed the affidavit of probable cause, and I do find the defendant, as the person sitting in the driver's seat, had certainly constructive possession of all of the items inside that vehicle, especially those that were not in plain view. And here he was found to possess a number of drugs, and also found to have the scale. So I will find that there is probable cause. However, I also recognize that it's unlikely the state will be able to prove, based on these proofs, beyond a reasonable doubt, that possession with the intent to distribute. But we're not that far yet. This is merely a probable cause determination. And I believe they have presented some evidence that arguably does support the idea that he was prepared to somehow divide and package based on the presence of the scale. So I'll find probable cause does exist for all of the charges. Mr. Williams, you may proceed.
Thank you, Your Honor. The state would like to note that the PSA does show the defendant does not have an extensive criminal history. However, that could be interpreted two ways. It could be interpreted in a manner that shows this is a first-time offense, or this could be somebody who's managed to go unchecked up to this point. And we feel that the weight of the evidence here and the nature and circumstances of this case are substantial, and that the PSA does not reflect that adequately, given that the firearm with hollow point bullets poses a severe danger to the community, on top of the fact that this was a charge found, or the charge brought against the defendant also stems from the location where he was found in a school zone. We feel that those 2 points do indicate that the defendant poses a danger to the community should he be released. And the state submits that detention is the appropriate measure at this time, and that, once again, the PSA does not adequately reflect the gravity of the nature and circumstances of.
I mean, I understand the word detention is correct, but do they have to use the word detention? We are all traumatized by how much time we spent in detention decades ago. Do they really, really, really have to use the word detention? Yeah, Donald, he had hollow points. Hollow points. Can't they use something more stronger, torture chamber, maybe, than detention? Can't they?
This case. Thank you.
Ms. Cox.
Thank you, Judge. As you might guess, we think that the PSA does adequately reflect the circumstances of this case. You know, the argument that that the lack of criminal history could mean that he's just a great criminal, never got caught with it, is, I think, just a very unfair argument.
I agree with that one.
Puts us in a position to try and disprove a negative, and I'm just not willing to do that. I don't think there's a need to do that. This individual doesn't have a prior criminal history, except for one disorderly persons offense of hindering, which stems from an initial charge of possession of marijuana and hindering. So it looks as though he pled guilty to the hindering rather than the marijuana possession in a municipal court back in 2021. I would say that the police report indicates that Mr. Green indicated to law enforcement the reason why he was pulled over was because indeed he was appearing for a court appearance in municipal court. He got very tired and he fell asleep in his vehicle. As far as the strength of the case, I would just mention that the facts as they read in the police report, unless I'm missing something, I'm not certain how they got Mr. Green out of the vehicle. So once he's out of the vehicle, then yes, there are things in plain view that
Taser,
obviously
maybe
give them the authority to then get into the vehicle. But I think that there is at least a colorable motion to suppress with regard to the initial, perhaps illegal request or demand for him to exit that vehicle.
Can you cite any authority that says the police don't have the legal ability to order anybody they encounter sitting in the driver's seat of a motor vehicle to exit that vehicle? This is the passenger. This is the driver.
Well, he wasn't doing anything illegal, Judge. He was sitting in a vehicle.
Well, he was suspected to be sleeping in the car. And I believe the initial officers then suspected that he may be under the influence. And indeed, it appears, based on the evidence found subsequently, and
I don't
not
like
suggesting
this argument.
bootstrapping works here.
Yes, you are.
But
That's what you're doing.
generally, as a rule, it's not a good idea to operate a motor vehicle while injecting heroin.
Well, we
and so-
certainly don't disagree with that statement, Your Honor.
So he then pulls over, and the police have to knock on, they have to awaken him. He starts the car to roll the window down.
So apparently in this court, there's two prosecutors, but the bottom one gets to interrupt.
Demonstrating a present ability to operate. I don't know, did they charge him with DWI?
It doesn't appear so, Your Honor. In some of the reports that
I don't have the motor vehicle, so I don't know.
Yeah, doesn't appear so. The reports indicate that he appeared nervous, but he didn't seem to need medical attention in any way. EMS was there originally, and they indicated to law enforcement that arrived later that he appeared fine. He didn't need any medical attention. So I think that would indicate that, at least at that time, those individuals did not believe, or law enforcement and EMS did not believe that he was intoxicated. So no, testing was done with regard to whether or not he had ingested illegal drugs at that time. But I'll leave it at that, Judge. It's one point about the strength of the case. I understand we're not on trial here. I would say that we think the PSA is very appropriate here. This is an individual who is 42 years old, has only one prior disorderly person's offense of hindering. I'm not sure what the facts of that hindering were. I did ask Mr. Green, but he was really unable to recall. He just remembers that he had marijuana on. So I can't really speak.
I don't remember his name from yesterday, but who else keeps watching the door behind the inmate to see if Mr. Winnitz is walking around back there?
To that, but I'll say that he's been the owner of One Stop Auto on Freeland-Heisen Ave for 3 years now. So he is employed, and he employs other people. He lives in his own apartment with his girlfriend here in Elizabeth, just down the road. And I just don't see what danger he poses outside of the fact that, he's got a gun, and I understand I have to concede in some ways that obviously guns pose danger. He wasn't using the gun. I don't know that it was loaded as far as I can see from discovery. And I just think that the PSA recommendation is the most appropriate recommendation here.
Yeah, my recollection is that there was not one in the chamber, but he did have a magazine that was loaded with, as I recall, 8 hollow points, and that the magazine itself was a large capacity magazine.
Yes, that's accurate.
My concern here is that drugs clearly are a danger. Illegal handguns are clearly a danger. And the synergy, as it were, of illegal drugs and illegal guns together is a toxic brew. Is that too much? That's too much. But what are we doing to address his substance abuse problem?
Well, Judge, I don't think that Mr. Green believes that he needs assistance with that alleged drug problem. I mean, I'm not going to sit here and say I don't see the facts as they are. In fact, when I first saw them, that's the first thing that I asked Mr. Green in the consult room, because he says he was taking a nap. And I think that everybody sitting in the room can sort of read between the lines there. But I'm not sure that drug treatment or forced drug treatment, or I guess I should say keeping him detained until I get him a drug treatment, is an avenue that I think is wholly appropriate here. I think that the court can place conditions on him that do require him to get into a drug treatment within a certain amount of time, and to provide proof to Your Honor of that drug treatment admittance. And if he doesn't, then he's facing a violation of monitoring, and I would assume a revocation of release. So that's what we would ask the court to do if you are indeed concerned about any substance use disorders.
Very well. Mr. Williams, anything further from the state?
Your Honor, just would like to clarify that was, I believe, 11 hollow points and a maximum capacity of 14. And it is correct that there was not one found in the chamber, but nothing further.
Very well, thank you. The
Very
court has reviewed the
persuasive.
complaint PSA, the plea, of the defendant's criminal case history, the papers filed in support of pretrial detention, and I've heard the arguments of counsel. The PSA in this offense indicates a score of 2 out of 6 for failure to appear, 2 out of 6 for new criminal activity. There's no new violent criminal activity flag raised. The recommendation of pretrial services is to release on level 1. The defendant is 42 years of age. This offense does not involve a crime of violence. He had no pending charges at the time of this offense. He does have one prior disorderly persons conviction for hindering.
I'm not gonna
No
lie.
prior indictable offenses. He's
The next like 7 minutes are boring. He's just going over the bond conditions, which we've all heard a million times. So I'm going to fast forward it a little bit because it really, truly is boring. I promise you. Let's just go to here.
It is not a forfeiture of the firearms. It is simply a surrender for purposes of safekeeping. Do you understand that?
Yes, sir.
Okay.
Yes, sir.
You shall refrain from the excessive use of alcohol or any use of narcotic drugs or controlled substances unless they are specifically prescribed to you. At this juncture, I am not placing you in home detention, so you are free to come and go to work, report to pretrial services, meet with your attorney, go about your life as you choose to, except, of course, that you do need to come to court when required, and you do need to report to pretrial services. In addition, I am ordering that you undergo a substance abuse evaluation and then follow whatever treatment program, if any, that they recommend. So
I started all what he said. We're in Jersey. They don't say no alcohol, no drugs. They say no excessive use of alcohol and absolutely no drugs of any kind. That's Jersey. You can still have alcohol, just nothing excessive.
So you need to provide proof that you've scheduled that within the next 7 days. And you provide that proof to pretrial services. If you need to, the public defender's office maintains a list of available treatment programs where you can get that evaluation done. So call your attorney. They will be able to give you a list of providers and can assist you in making an appointment to get that substance abuse evaluation completed, all right?
Yes, sir.
Okay.
Yes, sir.
You must notify the court immediately in writing if you're detained in jail, in prison, or otherwise cannot appear at a court proceeding. If you fail to appear at a court proceeding and you're arrested in another state or jurisdiction, then you agree to waive all rights to extradition proceedings under the New Jersey statutes and or the demanding states statutes in regards to extradition law. Your failure to appear, a violation of any of the conditions of your release, or the commission of any new offenses may result in the following penalties or consequences: the issuance of a warrant for your arrest, increasingly restrictive conditions, revocation of your release, forfeiture of any monetary bail, and your possible detention. Do you understand all the terms and conditions of your release?
Yes, I understand, Your Honor.
All right, very well. Then you'll be released sometime this afternoon. Please make sure you call pretrial services right away to set up your appointment schedule. And please make sure that you schedule your substance abuse evaluation and provide proof that you've done that to pretrial services within the next 7 days, all right?
Yes, sir.
Okay,
Yes,
your
sir.
matter's all done. You can let the jail know you're done and they can send in the next person.
Thank
Okay,
you.
now leave the booth. Whew. All right, guys, we made it. That's what I got for you today. A couple new judges. I know. He made me tired too. I don't know if exactly. Thank you, legal. Thank you. Somebody said it. Excessive is a related term. I mean, what is excessive? So 2 beers for me would absolutely not be excessive in any way, shape, or form. That's warm up. So I don't even know. It just feels like a trap to me. A trap. I don't know if I'm gonna play. I don't know if I'm gonna create a video of the car dealership. I think I'm gonna leave it for tomorrow's stream. So in 24 hours from now, we'll play that because I gotta get to work. I gotta get some stuff done before I go to work, like sleep. Oh, happy Father's Day, guys. I really, really do hope you guys have a really great Father's Day. Yep. And I thank you so much for coming out. I really, really do. I do thank you for the people in Patreon whose subscriptions are renewing for another month. I appreciate it very much. Thank you so much. Darkest Night again. Thanks for the computer fund. Hopefully they're already shipping it back. You guys get some rest too. Oh, sorry, Caroline. Didn't put that up there today. And all you lurkers, B24 Liberator, hello. Have fun in my comments. Texas Vernon, I hope you're doing well. She's not slipping. She's not late, Fozzie. The stream is only an hour long today. Normally, it's 2.5. So she's right on time. All right, guys, be good. Come into Discord. If you want to talk more, come into Discord. I'm not getting on Discord voice today as I really have to get some stuff done. I worked a double yesterday, but come into Discord and you can chat with all of us, and post a meme. Bye, guys. Thanks.